Good morning, everybody. My name is Tony Wayne. I am the co-chair of the advisory board of the Mexico Institute at the Wilson Center in Washington. And we are very fortunate to have a number of excellent representatives of a private sector perspective to look at the proposed legal reforms, constitutional changes of the judicial system in Mexico. This is a second event we've had on this. On Tuesday, we had a discussion among legal experts about this proposed judicial reform, and that discussion is available on the website of the Mexico Institute at the Woodrow Wilson Center. But today we're going to have a fun discussion with representatives of US and Mexican business organizations and perspectives to look at the impact this judicial reform could have on the private sector. Not just the US private sector, Mexican private sector, the US private sector, and other international companies that would be that are operating or would be considering operating in Mexico going forward. So we're very happy to have with us today Antonio Ortiz Mena, who is a partner at the DGA Group and an adjunct professor at Georgetown University. Dylan Clement, who's the director of international policy for the National Association of Manufacturers. Pedro Casas Alatriste, who's executive vice president and general director of the American Chamber of Commerce in Mexico, based in Mexico City. And David Gans, who's the William Clayton Fellow in Trade and International Economics at the Baker Institute, where there is also the US-Mexico Center at the Baker Institute. So I think we'll get a good variety of views. And just as a reminder and introduction to everybody, this judicial reform is coming in a situation where Mexico very much wants to encourage nearshoring into Mexico. They want to help expand resilient supply chains between Mexico and the United States and Canada as part of the USMCA trade agreement. And the new administration wants to try, Mexico wants to try to involve more PYMEs, more SMEs in these supply chains and in these production networks. So all of that demands a very accommodating and supportive investment environment. But for many observers, the proposed judicial reforms are introducing uncertainty on a number of different fronts for Mexican, American, and other private companies. People are asking, well, what kind of a transition are we going to have where we might be replacing over 1,500 federal judges? Who will these new judges be? What will happen to the cases that are currently pending? What will the quality of the new judges be? What will the impact be on some of the changes in how individual cases are being considered that will limit the impact of one individual decision to similar cases in other areas? Mexico already had a number of steps that most observers believed it needed to take to improve the investment environment. So will this judicial reform just add to that uncertainty or not? For example, does this judicial reform really help with the problem of impunity in Mexico? Does it really help with the challenge of corruption? Does it help with the backlog of judicial cases that currently exist and the very slow process of that? Or will they be complicated going forward? So let's have a good discussion of this. And I would like to ask Antonio Ortiz Mena to start us off with a few comments.
Yes, thank you, Ambassador Wayne. A pleasure to be here. As was said in the introduction, I'm a partner at DGA Group and a professor at Georgetown University, but I want to state that I'm speaking on my own personal capacity, but very glad to share my opinions. And Ambassador Wayne, what I thought I'd do is to give a context, given I'm the first one that's speaking, and we're giving a perspective from the private sector, why they have expressed some concerns. So I don't want to get this discussion to get a bit lost in the weeds, so to speak, about legal issues. What's going on here? Okay, So basically, in my over 3 decades of dealing with trade and investment issues between Mexico and the US, I've learned that companies hate surprises because they make investments usually with returns only in the medium to the long term, and surprises change their calculations. How do they think about this? They think, what is the return that I will get on my investment? And what is the risk level? And then they compare returns to risk and decide whether to invest or not. This proposed reform would, as far as we know, probably increase the level of risk. So if the level of return does not increase at the same time, it will be more difficult for foreign businesses and even Mexican businesses to invest in Mexico. So this is, the basic issue. I would say that the NAFTA in the early 90s and the USMCA, which is NAFTA 2.0, were negotiated precisely to establish clear and stable and predictable rules. They were established to avoid surprises. I would say they were not established to reduce tariffs to zero or to have free trade. That's a means. The end, the objective is to have no surprises. And this involves two issues. Number one, day-to-day normal transactions for trade and investment. And number two, how to resolve disputes. It is normal to have disputes in business. The key is how they are resolved. So this is the background. And I would say that some businesses over past decades have had difficult experience. I'm not going down to prehistory, but just to give you two examples. In the early 1980s, then Mexican President López Portillo suddenly nationalized banks and imposed exchange controls. And businesses, foreign and domestics, decided that they needed more veto points, more checks and balances to avoid these things. The next president, de la Madrid, was very much pro-business. Mexico joined GATT, but still, policy reversal and surprises were possible. So it was not enough to have a pro-business president. This is where NAFTA and the USMCA come in. But I would say that NAFTA and the USMCA on their own are not enough. They're a complement. They work with the domestic legal system. And here is where some businesses are facing some questions. And I would say that the questions have to do with the potential erosion of checks and balances in Mexico. Would the judicial branch be co-equal with the executive branch and the legislative branch and respond to different incentives? If judges are to be elected, will they respond to the same electoral base that elected the Congress and that elected the president? And if so, it would be difficult for it to be truly independent, to serve as a check and balance. What will the incentives of judges be to keep their position, to be elected, etc.? What profiles would be needed for them to be elected? So aside from getting into sort of the details, the concern isn't about the individuals per se, but about the incentives that the new members of the judicial branch would face and how that would affect their behavior. So the main concern here is one less veto point, an incredibly important veto point that would generate uncertainty, that could potentially increase risk, and that would deter some more investment going into Mexico. I would end this introduction by saying that the reform of the judicial branch, I think, is necessary and welcome. Let us accept that there is corruption, that there is inefficiency, that there is lack of transparency, and that there is already risk in terms of uncertainty regarding the judicial branch. We're not, happy, perfect, don't touch it. No, far from it. I think reform is necessary and welcome. The question is whether, as we understand it, the proposal reform would, improve, transparency, accountability, reliability, and predictability so that we have a strong and independent judicial branch that is good as an end in and of itself in terms of checks and balances, but that would also help bring more certainty and therefore attract more investment into Mexico. So this is the way I see it, and some of the companies I speak with see it in terms of what's going on and why they are concerned, Ambassador Wayne.
Thank you, Antonio. That's a wonderful introduction. Dylan, let me ask you to give a perspective from working with all the companies that you work with as one of the largest business associations in the United States.
Yeah, thank you very much, Ambassador Wayne, and thanks to the Mexico Institute for having the NAM on this panel to provide our perspective on Mexico's judicial reform. I think that Antonio's lead-in comments were very, very good, totally excellent. For background, the NAM is a trade association that represents over 14,000 manufacturers in the United States, and our membership spans a diverse set of industries. Pretty much everywhere. We have autos, we have pharmaceuticals, we have chemicals, telecom, semiconductors, heavy equipment, mining, oil and gas, renewables, logistics. We are everywhere. And as is well known, President-elect Sheinbaum and the Morena Party achieved an amazing, resounding political victory in last month's federal and state elections. They clearly have a mandate to govern, and should they choose to do so, implement sweeping changes to their economy, their government, and their society. But what our members are most concerned about is whether and how President Obrador and President-elect Sheinbaum will pursue the constitutional amendments introduced in February. And the real question that we are asking ourselves is this: will these amendments, such as the proposed elimination of independent regulatory bodies, and especially the judicial reform, negatively impact the commercial climate in Mexico as a place to do business and invest? This completely dovetails with what Antonio was saying. Over the past 10 years, manufacturers in the US have dramatically expanded facilities and operations in Mexico, totaling over $25 billion. And that's according to the US Commerce Department. Unlike other sectors of the economy, investments made by manufacturers are difficult to pick up and move if conditions change in a host country. Just look at the challenges that some companies are facing currently as they try to diversify their supply chains away from Asia. When manufacturers invest, they sink large amounts of capital literally into the ground, which is costly to relocate once built. And therefore, strong property rights and the rule of law are absolutely crucial for manufacturers when making the decision on whether to expand operations in a country or make that investment there in the first place. So let me be very clear. We don't pretend to know how the judicial reform is going to play out in Mexico or the impact that it's going to have on Mexico's business climate. And we certainly believe that the Morena Party has a clear and sovereign right to advance its judicial reforms. But with all that said, manufacturers are very fearful of the risk associated with enacting sweeping changes to the judicial system in Mexico on such a short timeline. In a worst-case scenario, these changes could erode the rule of law in Mexico, enable more corruption within Mexico's judicial system, weaken due process, and fundamentally undermine the functionality and independence of the judicial branch. And I think that the vital economic relationship between the US and Mexico, which is predicated on strong two-way investment flows, is too important to ignore the downside risk of getting the judicial reform wrong. In recent years, manufacturers in the United States have made record investments in Mexico. Over $5 billion went into the country in 2022 alone. And in 2023, Mexico overtook China to become the United States' largest trading partner. So I can understand how some Mexican leaders might look at these statistics and say, well, irrespective of what happens with the judiciary, it won't have that big of an impact on our inbound investment picture. But ultimately, it's going to be the marketplace that decides that. Strong property rights are the cornerstone of manufacturing FDI considerations. And in Mexico, we are already seeing a worrisome trend on this front. In its Economic Freedom Index, the Heritage Foundation has found that Mexico's property rights have backslid in every year that President Obrador has been in power. And there are instances of this. In 2020, the Mexican government compelled Constellation Brands to move a factory it had been building in northern Mexico to southern Mexico. The company had spent nearly $1 billion on that factory, and it is unclear if they ever received any compensation for it. And more recently, the Mexican government appears to have seized a $2 billion mine belonging to Vulcan Materials, which is another US manufacturer. So at the end of the day, manufacturers want to partner with Mexico to help it prosper economically, to help it grow its industrial capacity and make it more self-sufficient. President-elect Sheinbaum has an ambitious domestic agenda, which will likely require inbound FDI to achieve given her fiscal deficit. And we want to help her administration be successful. Mexican leaders have also expressed, as the ambassador noted in his opening, a goal to have Mexico capitalize on the desire of companies and policymakers to reshore and nearshore their supply chains closer to the United States. But these objectives could totally be undermined by the judicial reform as well. What we've seen so far in terms of nearshoring in Mexico is that much of the new investment in Mexico has come from companies expanding their pre-existing presence there, not necessarily new manufacturers making greenfield investments. And what that tells us is that it shouldn't be taken for granted that manufacturers will invest in Mexico just because recent inbound investment has been high, or because companies view Mexico as a potential candidate for considering how to make their supply chains more resilient. There are alternative markets where this can happen too, and so Mexico is competing with other countries for this investment. For these reasons, the NIM would caution against rushing the judicial reform through in September, and given that it'll have an impact on its investment climate for decades to come, and so many questions about it are unanswered, we think it's better to get this right than done quickly. And so with that, I'll turn my remarks over to the next speaker.
Thank you very much, Dylan. That's a very useful set of perspectives on this. Pedro, could I ask you to offer some perspectives from working with all the Mexican and American companies that are in the chamber that you represent?
Absolutely, Ambassador. And thank you so much for the invitation, also to Lila and the rest of the Wilson Center's team. I'll go right into the chase. I'll try to divide my initial remarks on three main topics. One, as Antonio's intervention ended, I will highlight a few positive things that we see on this reform, which are it's important also to highlight. Secondly, I'll go into the challenges and worries that we're seeing, and I'll end up kind of underscoring the impact on investment, USMCA in particular, and kind of the economy at large. So let me start by highlighting three things that we believe are positive about this reform. First, the reform introduces a separation between the administrative and the disciplinary functions of the judiciary and the presidency of the Supreme Court. This change aligns with international recommendations and strengthens the role of a constitutional court by ensuring that no individual holds multiple key positions simultaneously. So this is definitely a good thing. The second one is that the reform includes provisions that prevent political parties, in theory, from endorsing judicial candidates and bans public or private campaign financing. So this is absolutely positive. Nonetheless, it doesn't explain how the campaigns will be placed without budgets. But initially, in theory, sounds good. And the third point that I will positively highlight is that this reform decreases the duration of fiscal and criminal trials. Again, this is a positive step towards enhancing a judiciary efficiency and expediting justice. Again, praiseworthy theoretically, but in practice, it could actually lead to more bureaucracy, and we could go into further detail during the discussion. Now, passing on to the second part, challenges and concerns. The initial one, and this is very much related to USMCA, which I'll go at the end, is that we in Mexico are currently going over the implementation of previous judiciary reforms enacted during the current administration of López Obrador, actually, which could be completely rolled back if this reform goes forward. So, for example, in 2017, President López Obrador enacted a constitutional reform to transform the labor justice system, which far-reaching implications to implement and comply with the obligations assumed by Mexico through the USMCA, which, among others, includes having independent and impartial courts to review labor disputes, such as workers' collective bargaining negotiations. And further on, in 2019, the Federal Congress enacted a series of additional legal reforms which mandated the creation of federal labor courts, independent from the executive power, to replace the previous conciliation and arbitration boards. The Federal Judiciary Council is now working extremely hard to implement this because, additionally, it's going under a kind of difficult scenario with budget cuts and other financial restrictions. So all of that could be rolled over if we pass through this reform. The second thing that worries us, and going over a little bit of comparative politics with other countries, we've analyzed the case, for example, of Bolivia and even the US, and we can see that where there are direct elections of judges, sometimes or often they fail to ensure judicial independence, and that could lead to increased political influence. Obviously, this raises concerns about the potential negative impacts on the impartiality and effectiveness of the judiciary in Mexico, which was some of the things that Antonio was mentioning previously. The third thing is kind of budget and logistics, kind of just doing the math on how this is going to roll out. And the introduction of a popular election for judges may lead to high costs and procedural complications. There are worries about the potential of unfair or unlawful dismissal of judges, the increase of expenses from implementing this new system. And obviously, we're suggesting, at least if this goes on, a gradual reform process and implementation to ensure that justice in Mexico is achieved efficiently and doesn't get into like a halt from one system to the other. And the fourth thing that I would highlight about the wariness that concerns us is kind of the risk that disciplinary procedures could be swayed by political biases. Currently, as how the reform is written, the provisions for disciplinary measures are excessively vague and open to interpretation. I could go into further detail. I know you guys analyzed the technical issues of the reform on previous days, but that is also something that concerns us. And now into my third and final remarks, I will go into the impacts for investment, USMCA, and the economy as a whole. First, on the investment front, and Dylan and Antonio already mentioned all of this, but the reform truly compromises the judicial independence, or if it's poorly implemented, it could, one, increase legal uncertainty and complicate proceedings, and number two, generate potential delays and higher costs, which could deter investments and disrupt the efficient resolution of disputes, which potentially undermines the effectiveness of the judicial system. This, in the business sector, obviously, is crucial that the judicial reform ensures the effective use of alternative disputes resolution mechanisms. That is also related to USMCA, which is the next topic that I'm just gonna explore, such as arbitration. So on USMCA, legally speaking, there's nothing that counterweights what is written in USMCA. Nonetheless, some of the things that are the critical issues stated in USMCA, which, by the way, had bipartisan support during the negotiation and approval in the US, include things such as the strengthening of labor standards in Mexico, the protection of intellectual property, advancement on some other issues in agriculture, the environment, and among many others. Now, the proposed judicial reform could significantly delay the professionalization and specialized justice for these issues in particular. This delay may hinder the federal judiciary ability to apply technical legal criteria and provide continuous training for judges, especially on these labor-related issues, as I was saying. And it is important to remember the Annex 23A, where Mexico is committed on having independent labor tribunals, and Chapter 31 on the use of alternative means for dispute resolution. These mechanisms are essential for resolving business conflicts efficiently and reducing the workload of the judiciary. A well-implemented reform should support the use of these tools to facilitate commerce, encourage investment in the country, and obviously strengthening the USMCA implementation. And I will end with the macro view in just a minute about the impacts on basically the economy. And it all goes down, again, Antonio and Dylan were mentioning, to three key concepts: certainty, trust, and effectiveness. The primary goal of a judicial reform should be to ensure the separation of powers and the existence of checks and balances. Both are essential for generating certainty. It is crucial that the reform does not undermine the legal certainty of the rule of law. We must ensure that these reforms uphold international agreements, the USMCA, which are obviously key to maintaining kind of the investor confidence in Mexico and in North America as well. The second one is that judicial transparency is critical for all investors as a key factor in maintaining trust. Trust is the second topic. The reform must establish the right incentives to ensure that judges, ministers, and so on remain independent and that apply their judgment freely when resolving cases. And to conclude, is that about stability and the effectiveness of the judicial system are vital for economic performance. Properly implemented reforms that strengthen judicial independence and transparency are essential for ensuring that Mexico remains a favorable environment for foreign investment. Thank you, Ambassador.
Thank you very much, Pedro. Excellent points. David, could I ask you to add some comments now, please? You're still on muted. Okay, we all do this.
Is that better?
That is better.
Okay, well, that's always helpful. First of all, again, my gratitude to the Wilson Center and to those of you who organized this panel. Secondly, I will reiterate that as a fellow at the Baker Institute, these are my own views, not necessarily those of my colleagues at the Baker Institute or their Mexico Center. So I'd like to, in 5 or 6 minutes, start out, but keep looking at another issue of context. The current investment climate in Mexico is nothing to write home about. It's negative. You have a president who doesn't really like investment, particularly foreign investment, at the same time when he presumably knows that Mexico's economy still heavily depends on the investment that is necessary to create jobs and maintain a very high level of exports to the US and elsewhere. You've had a series of expropriations over the last 5 years, which one of my colleagues thoughtfully referred to. And you basically have continuing arbitrary actions, including the army takeover of sectors which have traditionally been managed by the private sector. And you have, in this context, in part because of the taking of green power projects, a series of problems with the electric power system, where you have shortages, you have brownouts, and you have a very substantial lack of clean power. And you add this to all the other issues that we're all well aware of: corruption, crime, drug issues. So I think overall, the López Obrador record is rather negative. And certainly, as my colleagues have said better than I, it will get worse if these judicial reforms and some other reforms get passed, particularly in that period between September 1 and October 1, where you have essentially supermajorities for the Morena, which means they can do anything, including amend the Constitution, and October 1, where Claudia Sheinbaum becomes president. And I think one of the big risks for her, even though she's a supporter, is it's very possible by that October 1 that her hands will be totally tied in terms of a number of areas which are going to make foreign investment even less attractive. And if you look back on the last few years, the foreign investment level is significant. It's over 30 billion a year, according to my data. But it really hasn't changed much since 2019. And I think, and as again was mentioned earlier, about 90% of that is reinvestment by existing companies. It's not new companies coming to the country. And you have, again, the electric power shortages, and what I think upsets many of us, both in business and otherwise, is essentially Mexico is going through a once in a lifetime, once in a generation opportunity to take advantage of nearshoring opportunities brought about mostly by US policy toward China and the tariffs, but also by concerns over long supply chains and natural problems like the Panama Canal water issues or the Houthi attacks in the Red Sea. So it's an ideal time for nearshoring, since, as we all know, Mexico is far more likely to be a source of movement of Chinese companies or US-owned Chinese companies to Mexico than to any other developing countries. You know, there are benefits as well as problems with a 2,000-mile U.S. border. So there are studies that suggest that maybe the foreign investment in Mexico would be 1.5 or 2.5 times or 2 times as great if the investment climate was halfway reasonable. Third, I think the idea of judicial reforms, and I put reforms in question marks, is going to make it even more difficult for Mexico to show that it has any significant aspects of rule of law. Some courts, as you all know, have stood up to AMLO, sometimes in Amparo, sometimes in other areas, particularly the Supreme Court. The problem, I think, of the changes which may well make investment even less attractive is in part that if you think about it, the U.S. doesn't really have a great interest in protecting foreign investment. The Biden administration, and even more so a new Trump administration, if there is one, is extremely Buy American oriented. And I don't think either one of them are particularly interested in seeing jobs established in Mexico when they could be established in the U.S. as well. I mean, not everybody I know shares that view, and I'm putting it rather bluntly, but I think if you look at it carefully, if you look at the very limited complaints that the Biden administration has made toward massive expropriations in the power sector, we filed a case in 2022 and nothing has happened with it in the dispute settlement mechanism. I think it's probably true. And then finally, I will finish up very quickly. What some of us see in this is a reversion, first of all, to the pre-2013 energy reforms, going back to the status situation of the 60s and the 70s. And it's one it concerns me in part because I think if this happens in September, or if Ms. Scheinbaum decides she has to do it in October or November, it will maybe well be years or decades before those downturns can be reversed. Then, of course, although it's not part of the judicial reform, you have reforms which will increase the power of the executive branch to cancel existing licenses and contracts based on public interest or national security. Totally arbitrary grounds, which among other things will make, I think, corruption even more rampant than it is. So if you combine that with the fact that you have much less investor-state dispute settlement opportunities under USMCA than we did under NAFTA, and also that you have courts which will be even less sympathetic to business concerns than we have now, it's going to be a problem. And I think for a President Scheinbaum, by October 1, her hands may be tied. She may be hobbled by these changes. And I think U.S. pressure for reshoring is something we have to keep in mind. And I know all of you are very much aware of that. The Buy American policies, which could get even stronger under Mr. Trump, and the Mexican inability to compete with U.S. industrial subsidies in areas such as chips and electric vehicles and electric vehicle batteries. And you have all of these issues, which I think make it more difficult rather than less difficult for American companies that ought to be locating in Mexico to actually be there. And it just seems to me it's very unfortunate that as the López Obrador administration goes out, it's going to make it even more difficult for many investors to decide, yes, Mexico is the best place to be. Thank you.
Thank you, David. You make a very good point that we need to look at both the breadth of the other reforms being suggested in Mexico and what's happening in the United States, which is certainly with both of the recent U.S. administrations, and thus either of those that will be elected, there'll be a focus on Buy America, on investing in the United States. And of course, that's understandable, but from a Mexican perspective, you don't want to at the same time be making it harder to do that. The easier to do that, harder to have a deepening economic partnership with our southern neighbor, or either of our two neighbors. I'll add Canada in there too. So we had one question in the chat just to explain about how judges are currently chosen and how that would differ under this. Let me just, though some of you will know about it, you're not experts on it, but you know about that. As I understand, we haven't yet seen any criteria for the putting of people on lists. We know who would put people on lists to be potentially elected, but there's been no discussion. There's been discussion, but as I understand, there's nothing formally out there about, do they have to have been a zookeeper before, or do they have to have been a lawyer before? Do they have to have some experience or not? And maybe just start off with that. Is this judicial reform at all discussing the criteria for having somebody be on the list to potentially be chosen as a judge?
Yeah, so I could take that one. Let me divide the into two, because it's different between the ministers of the Supreme Court and the judges. So in terms of the Supreme Court ministers, currently the president puts forward three candidate proposals. It goes to the Senate, it gets voted. You need 2/3 of the Senate to get that approved. If that doesn't happen, then the president puts forward other three candidates and so on. And if that doesn't happen on a second time, then the president decides. Now, what the reform is putting forward is that the election needs to go over 30 candidates. 10 should be proposed by the president. 5 should be proposed by Congress, and other Congress and Senate, and then 10 by the Supreme Court itself. Then the Senate needs to verify the requirements to take the role, and I will go through them in a while. And then once they're approved, they can go to popular vote. Now, what are the requirements as the reform is written right now? One is having at least 35 years of age. Second, having a law degree with at least 10 years of having that title for ministers again. Here's where it gets tricky, because one of the requirements is having good reputation, and that's it. So what does it mean to have a good reputation? For example, I don't know, if you are the one judging a good reputation and you believe you're more inclined towards the left and a conservative, is that having good reputation or not? We don't know, right? So that's one. And then having been lived in the country 1 year before the election and not being previously a member of the cabinet. And then for the judges and the magisters, it's more of a judicial career. You need to go over tests and a series of tests and interviews and whatnot. And now it will be just directly put into popular vote. And the requisites for being a judge, now it's being a Mexican citizen, having 35 years of age to be a magister, and 30 years of age to be a judge. Having a law degree, again, having good reputation also, and not being a convicted felon. That's it.
Okay, thank you. Well, we know somebody who, I won't finish with that.
Ambassador, can I chime in with just one more small point on that?
Yeah.
From my understanding, another element that is concerning about this, and Pedro, you mentioned the good reputation criteria. There is also within the judicial reform an element of standing up a tribunal that is tasked with evaluating the actions of these judges. And so maybe you could speak, I mean, you probably know more about it than I do, but it's another kind of element that creates uncertainty when it comes to the stability of these judges. And then one small point of order that I watched there's been some comparisons. I think Pedro, you mentioned this too, of direct elections in the United States and the US system. And I think there might be some confusion about this. I was watching the panel on Tuesday, and I think one of the speakers basically, well, I misunderstood the point. Maybe she misunderstood the point. We have direct elections in certain states here, and that's clear. But at a federal level, the way in which the president will work with the Senate to confirm judges is not, as in Mexico currently, where the president ultimately has the final say if the Senate rejects those candidates. There have been many instances in the US history where Senates controlled by a different party from the president have outright rejected judicial nominees. And then there is no way going forward through that. And then also, when it comes to many federal judges, when the judges are coming from states, and I know this is kind of nuanced and maybe off topic here, but I think it's worth because this comparison keeps being made. For states where there's a Republican and a Democrat senator, more oftentimes than not, they're working together to agree on the nominee from the president. And so there's bipartisanship there. It's not as if the Senate is, solely working in partisan lanes towards or against the president. So just a little bit of context in terms of the American way that differs from how Mexico currently operates and certainly how it operate with these reforms.
Right. I think that's very good. So let me invite also questions from anybody, any of our audience who'd like to send some questions in. And one of the topics that came up here was financing of campaigns and how it's unclear right now. Can't be publicly financed, can't be privately financed. Well, that would seem to me and seem to a number of observers to open up what we might call corrupt financing, right? Private financing either by very wealthy economic interests from the private sector or individuals, or very wealthy criminal organizations of which we know there are a number with a lot of money in Mexico, and they're already funneling some of that money to public officials. So what are thoughts about this electoral, how to secure an electoral process, even if you're seriously considering the possibilities here? Please, anybody have any thoughts on that?
There have been some issues, I think, in some U.S. states over election of judges, where, for example, a judge has to run for re-election, and he or she is asking many of the lawyers who appear before her to contribute to the campaign. So there obviously are situations, I'm thinking of parts of Arizona, there obviously are situations where there at least is an appearance of impropriety, even though I'm not at all sure that there actually has been much. But Arizona's strange because many of its judges from the large cities are appointed by are offered by a nonpartisan panel and then appointed by the governor. In the smaller counties, it's an election process. And of course, in Texas, it's all election.
All right.
And Ambassador Wayne, if I could just kind of go a little bit deeper on what Dylan was asking about this new kind of a committee that is responsible for the discipline of the judges and so on. There are certain faculties, that, as I was mentioning in one of the points I said, that there's definitely a risk that disciplinary procedures could be swayed by political biases. For example, some of the things and some of the sanctions that this new body could go over in saying, well, a judge, for example, acted against the law. Okay, that's fine. But there's some lines that said, for example, that they acted against public interest. So what does public interest means? Let's say that the government is building, I don't know, a oil refinery or a train that is kind of cutting half of the jungle or whatever. If you kind of stop something like that from happening, is that going against public interest or not? So those are kind of the vague statements that definitely produce some political disadvantages for the judges when acting and trying to resolve any of their cases.
Yes, and I know you just picked those examples out of the air, hypothetically.
Absolutely.
We have a couple of questions also, or Antonio, go ahead, and then I'll mention the questions.
Yes, thank you, Ambassador. Just in terms of undue influence, etc., let me again take a step back. And I do think that, both USMCA panels and, domestic legal resources in Mexico should be focused on an unbiased and correct interpretation of the law, and that it be fact-based and, when necessary, science-based. Because I also sense a political economy tension, if I might say this. Will the courts in Mexico, from the lower courts to the Supreme Court, be sympathetic to business or not? Will they be sympathetic to labor or not? And my own, pretty purist view of this is that they shouldn't be sympathetic to anybody, either capital or labor. They should just be focusing strictly on the law, its interpretation, and on facts. And let me just give an anecdote about USMCA when this was not the case. There have been very few panels under the USMCA's rapid response mechanisms. Most disputes have been resolved before they reach a panel stage. Now, there was a panel over the San Martin mine, and in that case, Mexico won. And I heard some voices from the US federal government saying that the panel had not delivered because the panel did not deliver in favor of labor. And I thought that USMCA panels were supposed to deliver in terms of correct interpretation of the law and commitments. Not if it's in favor of labor, then it's good. If not, it's bad. Or someone could say vice versa, right? Some other cases have resulted against the interests of companies, and I don't think that's bad. So my sort of wish and recommendation would be to see how we can have the best neutral system. I don't want them to be sympathetic to anybody. I want to be professional and independent, and if I might, fearless about who gets upset or does not get upset. That's the way. So that's where I think we should be heading.
I think that's an excellent point, and just let me then, and you'll have a number of commercial cases that will come forward, of course. So you would hope the judges would know something. Some judges, there's no provision for specialization, I think, in here also. So you could get some various, as was mentioned with the labor courts, Pedro, as you mentioned, but you could get competition cases coming, right? And you could get, especially because they're moving some of these independent regulators under other reforms into the executive branch, you could have cases coming with some very technical issues. Is there a provision for training of judges, both in the sense that Antonio was talking about, which is what's the goal of being a judge? Because getting a law degree in Mexico is a lot different than getting a law degree in the United States. Let's say it's a very basic law degree that you get. You don't do the 3 extra years that you have to do in the United States, right? It's just an undergraduate degree in law. Am I correct here in most cases? So it's like getting an undergraduate degree in law, and that qualifies you for being a judge. Well, many of us would say, well, how does it do that? So is there anything in this proposed reform about training people as if they get elected as judge, do they have to go through training courses, or is there anything about professional training and aiming at the principles that Antonio was talking about here, where your purpose isn't to favor one side or the other, your purpose is to apply the law in an unbiased way?
Well, not as it's written currently.
Right.
There's none of that.
Okay, yeah. So I mean, and so looking at it from a private sector perspective, you just don't know what you'd be getting, depending on where your case went, who this individual is. David.
I would just add that in Mexico, the last time I looked, there were more than 1,000 law schools, which is about 5 times as many as in the US. And some of them were very, very small and fly by night. And I would also add there is no bar exam in Mexico to getting your licenciado. So I think your points were very well taken.
Yes. So one of the things that when I was working on Mexico, that we were trying to support was the creation of a bar exam, working with the associations of lawyers and others who were very supportive of this, because once they got into the practice, they could see the value of having a lower of a bar exam rather than having anybody who got out of law school claiming they could be a lawyer. And as I understand, there's nothing really about that area in this reform. So you could have a great variety of quality of people that would be considered. Let me ask another question. Is there there was an indication that there was going to be a period of debate about these reforms. Has there been an invitation to the private sector to any members of the private sector actually to offer their comments, their input, to have a back and forth with those who are considering this debate or considering this issue in the legislation in Congress?
So on our end, there was not a direct invitation. Nonetheless, we registered to be part of this open national dialogues, as they're called. Nonetheless, we haven't had any type of response. So to be participant of those dialogues, at least that's our personal case.
Okay, yeah, thank you. I have not, as you know, in the United States, though it's far from perfect, but we often have a public consultation period that's required or in the executive branch. And then Congress will have hearings, sometimes which aren't that serious, right? Sometimes they're political, but a lot of times they're very serious. And especially in technical areas, and you have very qualified experts coming and presenting and submitting not just oral testimony, but written testimony for consideration by the legislators. And has any of that, well, we don't know yet. We'll watch, but that's not a regular practice, as I remember from my time there for the Congress in Mexico. It happens sometimes, but okay. Let's see here if we have any. And has there been any discussion at all about how the people who are supposed to vote for these individuals actually learn who these individuals are or what their qualifications are? Are you aware of any proposals or discussion of that? I mean, if I had to vote for a list of 30 individuals to go onto the Supreme Court and there could be no campaign funding, how would you find out who they are? And I think I try to educate myself pretty regularly, and I read a lot, and I know a lot of other Americans don't. But is there any examination of that process that any of you have seen so far? Okay.
So, I mean, and if anyone has complementary information, please pitch in. But from what I know, there will be free airspace in the radio. Yet again, if you're talking about potentially 10,000 candidates, because once you add up the ministers, the judges, and the magistrates, you get around 10,000. So imagine giving space for campaigning in radio, public radio, to 10,000 people. I mean, do the math. I'm not even sure if we have that amount of time available on air. I don't know, but that's the only thing that's been proposed officially.
Well, thank you.
Through legal channel.
And that makes clear the scope and magnitude of this proposed reform and the challenges of implementing it. It would be very, very massive here.
Right.
So let me invite everybody we'll go around unless I'm trying to look through the Q's and A's here to see if we have, we've touched on a lot of this. I do want to mention that a number of organizations have put forward some of their views of alternative justice reform proposals. I read one from Mexico Evalúa, another one from Mexicanos contra la Delincuencia, and I'm sure there are others also, with people saying, okay, if you really want to change the judicial reform, here's a multi-point way to do that. So there are ideas out there of how this could be done. But why don't I invite everybody to make a final statement, a final set of comments, and maybe we'll go in a reverse order this time, and I'll ask David, and then Pedro, and then Dylan, and then Antonio to make some remarks.
Okay, well, I think for me, one of the most troubling aspects of what's going on in Mexico today is that we essentially, if this judicial reform goes through, are going to have one-party government in Mexico, at least for some period of time. You have a Morena president-elect, you have a supermajority in the House, and effectively a supermajority in the Senate. And if you have judges that are elected, the odds are most of them in most places will be Morena selected judges. I mean, we don't really know this. We don't know how this process of 1,500 judges is going to work out. But to some extent, this seems to me to be a reversion to the one-party government that we saw in Mexico before 2000. Thank you.
Thank you, David. Pedro.
Yeah, I guess I'll highlight what Antonio very wisely said, which is the private sector is not very keen for surprises, and having abrupt changes in an entire branch of power is quite troubling. And just to give you one example for the audience, in case you didn't heard this on previous panels, but for example, talking about the ministers of the Supreme Court, we're talking about having our current 11 ministers from one day to the other getting fired from the job, and having 9 new ministers in the Supreme Court from one day to the other. Imagine the impact of that turn of events, and then extrapolate that to the entire judicial system. So basically, kind of the big 3 topics I was ending my initial remarks were certainty, trust, and effectiveness. I would just kind of invite also everyone involved to try to dig deeper into the implications of the reform. I think that in Mexico, we've kind of narrowed the debate around the pros and cons of electing people, electing judges. And that's an interesting debate, but this goes way, way deeper. And we should take this seriously into discussion. I would like to thank the Mexico Institute and the Wilson Center to open these spaces for that, having a thoughtful and deep conversation about the topic. And let's hope that we can participate on official channels for this debate and putting things forward, and then we can actually have a reform that actually improves the justice system in Mexico, which, as Antonio was saying, again, sorry, Antonio, for quoting you so much, it definitely needs improvement. Thanks.
Thank you very much, Pedro. Excellent points. Dylan, please.
Likewise, thank you to the Mexico Institute for this panel. It's really important, and we appreciate providing our perspective. I guess something that I think in the conversation was mentioned but not highlighted was the direct linkage, in our view, of these amendments, including the judicial reform, to the USMCA and to the USMCA review in 2026. From my understanding, President-elect Sheinbaum has expressed a commitment to strengthen U.S.-Mexico trade ties and a commitment to maintain the USMCA, similar to the incoming Minister of Economia, Ebrard. And that is fantastic, because the USMCA is the cornerstone, the bedrock of North American manufacturing competitiveness globally, and we need the USMCA. However, going into the 2026 review, which we don't know what is going to happen at that time, like, it is uncertain, and there's already talk in DC and other places that potentially the review should turn into a renegotiation. That's not necessarily what we're advocating for, but it wouldn't be out of the realm of possibility, depending on who is the next president of the United States. And so currently, the problem is that with Mexico, there are a series of policies and regulations and actions that they have taken or not, which are in violation of Mexico's obligations under the USMCA. In telecoms, pharmaceuticals, chemicals, oil and gas, GMO corn, and these irritants are not going away. On top of that, now we have these amendments, which are in terms of water, electricity, the removal of these certain independent regulatory bodies, appear to be also in direct violation of the USMCA. And so on top of the policies which we have, there is set to be, come the review, a constitutionally embedded conflict with an agreement that Canada, the United States, and Mexico are trying to improve and make sure it continues for forever, hopefully. And the judicial reform is really kind of the cherry on top, forgive my parlance, because the USMCA unfortunately significantly eroded ISDS protections for investors outside of privileged sectors. And so what we have now with the USMCA is an investor in a non-privileged area must go through the local court system in Mexico first before seeking arbitration through the USMCA. And if this judicial reform were to go forward, and if the potential quality or lack thereof of judges, which has been mentioned by Pedro, comes into effect, it will really complicate the ability of manufacturers to utilize the USMCA and believe that continuing their investment, expanding investment, and making new investments in Mexico is the best decision. So we're very concerned about this. We're very concerned about not just the amendments, but the future of the USMCA, because these things are very important, not just for our members, but also for Mexico's economic prosperity.
Thank you, Dylan. I share completely, as you might tell from one of the books behind me, your focus on USMCA. Very important piece of legislation. And thank you for highlighting the fact that USMCA actually reduced the investor protection from NAFTA. And so it indeed does say you have to go through the local court system. So if the local court system changes significantly, that very much will change to prepare the way for Antonio's final comment, the risk calculation that businesses are going to be making. So with that, Antonio, please.
Yeah, thank you, Ambassador. Thank you again to Lila and her superb staff at the Mexico Institute for inviting me. And I have two final comments. One on the judicial reform, and secondly, a follow-up on the USMCA to complement what Dylan said right now. So on the judicial reform, my suggestion for, both Mexican and I guess a lot of US businesses that might be watching us is to take a very close look at the reform and just don't focus just on the fact of what you don't like, but think about what, if anything, it does to reduce corruption, because I think everyone shares that aim, what it does to foster greater independence, what it fosters to have better judges and therefore better decisions. So I think hopefully we can all agree those are the aims, and then see in terms of proposal whether or not there are elements to reach that or not, and if not, to propose some recommendations. I'll switch to Spanish. El trapito y el remedio, right? Don't just say, I don't like it. Well, why? And what do you propose? So far as we agree, we're pursuing the same aims. Okay, that's one thing. Secondly, regarding the USMCA, I am confident that whomever wins the US election will want to keep it because it's in the US's self-interest. And I understand that the next Mexican government very much wants to keep it and reinforce it and strengthen it. So I think that is good news. Now, there is indeed a rarefied environment in terms of a USMCA and disputes, but I would say that the US can do a lot to improve it. Number one, there has been one, general panel and between Mexico and the US, and that's in automobile rules of origin. And the US is not complying with that. So if the US is concerned about the rule of law and about enforcement, well, they should comply with the final panel report on rules of origin in autos. There has not been a panel convened, never mind issuing the report on energy. It's still at the conversation stage. There has been a panel convened for GMOs, but we have still not seen its final report. So as of today, the US, I would say, is sort of offside in not complying with a panel report. And secondly, to restate what I said about the San Martin case about a rapid response mechanism panel. Again, if the US says, if it does not find in favor of labor, I'll complain. And for example, in this instance, I believe USTR still asked the Department of the Treasury to block export from the San Martin mine. It might be illegal, but again, I think goes against the spirit, right? Okay, we don't like it, so we'll keep blocking because the RRM panel did not find in favor of labor. So I think those are things that the US can do and can control, and it would be good if they focus on that and then give recommendations, because I think, and it's as it should be, it's for Mexicans to decide what to do with the judicial reform, right? So those are my comments.
Thank you, Antonio. And just to pull back here. So the basic questions are, can the two countries prosper? Can the private sector actually help in that prosperity by investing more, investing better, creating more jobs, creating more wealth for for both countries? And does this environment encourage that? And I think that's what we're really trying to consider here most broadly. We want all people on both sides of the border to step back and really look at this. The ultimate goals are to help Mexicans and Americans prosper together, as is in our bilateral relations. How can we best do that, and how can we avoid pitfalls? And so we've had a wonderful discussion. I thank you very much to all of our participants. I encourage everybody to stay engaged on this issue, because it is going to be really one of the top priorities in Mexico City over the next 2 months going forward. And as we've discussed today, it can have very big long-term implications. So thanks to everybody for being with us, and we'll look forward to seeing you again soon.